benefits or whatever in federal court. And I'm just curious of what you might say about the incongruity of refusing to allow a state to have a similar exhaustion requirement that the federal government imposes on Americans.
Well, I don't think it's incongruous at all, because I think the practical effect of our rule is that most claims would be dismissed in state court if you're just seeking benefits for lack of merit because you've gotten enough process. In other words, if you just file a claim in the state agency saying, I want benefits, and then you get a bad decision from the hearing examiner, and then you just go straight to federal court and say, well, that was a due process violation. I didn't get a good hearing for the examiner. You would lose in federal court. The federal court would say, there's no due process violation. You have plenty of process in the state court.
I understand that. I think we're speaking past each other. So you're saying that Alabama can't have an exhaustion requirement, correct?
Only as applied to Section 1983 claims.
Yeah, right, okay. But if I were to challenge my federal disability benefit claim, identical claim, just against a different government, here instead of the state, the federal government, you'd almost assuredly have to exhaust your administrative remedies before you could challenge that decision. And I'm just curious how you reconcile that fact with the relief you seek here.
So I'm actually not sure that's the case if it's the type of claim we're asserting here. Like, suppose you filed a Social Security claim and it was stuck in the agency for 5, 10, 15
You'd have
years.
A futility argument, for sure.
Yeah, I think you'd be able to go to federal court. That's
right. But otherwise, you'd have to exhaust, right?
Right. And
that's what I'm getting at. Okay, so in the federal system, you have an exhaustion requirement with a futility exception. Assuming Alabama recognizes a futility exception, and I'll have that question for counsel. I've done a little research on it. Seems to have one. Why shouldn't a state be allowed to have the exact parallel situation that you'd have on the federal system?
I guess I think that argument is incompatible with the Felder case. I mean,
okay.
Look at all the reasoning of the Felder case. I think it would rebut that suggestion. I mean, the court held that the state is not permitted to put that type of barrier in front of the vindication.
What does Felder, because that is the linchpin of your argument, is that we've already decided this. So what kind of state procedural rules or rules does Felder still leave? How would you define the scope of that?
So Felder left two categories of rules that the state could apply in its own courts. One are neutral procedural rules. So it gave the example of rules governing substitution of parties and service of process, rules that don't just apply to plaintiffs who sue governmental defendants. And then the second category was certain jurisdictional rules, and Haywood elaborated on this. The court said that it's jurisdictional rules that reflect concerns over competence over the subject matter and the power over the person that jurisdictional rules are designed to protect. So, examples of such rules would be like in the Herb case, a jurisdictional rule that a city court can only hear cases arising from its territorial limits. The court upheld such a rule. Or a case saying that the state won't exercise jurisdiction over out-of-state defendants if it's an out-of-state plaintiff. The court upheld such a rule in the Douglas case from 1929. So those are the types of jurisdictional rules that would...
And do you view Felder as a preemption decision then?
Yes, I view Felder as a preemption decision.
And on what basis was the preemption?
So the court talked about purposes and objectives preemption in its opinion, and we actually have no problem with that. We agree with all of its analysis. I actually think there's a straighter path to the result in Felder. I just think there's a direct conflict, because when the court holds that an affirmative defense is not available, it just means it's not available regardless of whether the adjudicator is a federal or state judge. So I view I view Felder as a direct conflict preemption case. The court did couch it in purposes and objectives language, possibly because in that case it actually wasn't clear whether it was an exhaustion requirement at all. Unlike typical exhaustion requirements, you don't have to wait to the agency to rule. And so one of Wisconsin's arguments in that case was this isn't exhaustion like in Patsy. I think that's why the court walked through all of the reasons that the statute conflicted with the purpose of Congress. And then it said, well, actually we think it is an exhaustion requirement. And then Patsy's reasoning just follows.
What I guess I'm confused about from your answer to Justice Kavanaugh is how the jurisdictional and neutral requirements relate to the analysis in Felder. I mean, Felder's rule about whether or not it was preempted didn't seem to have anything to do with whether the rule was jurisdictional or neutral. So why do you suggest that that's somehow a way to get out of Felder's analysis about preemption?
Well, I think so. Felder specifically said the rule in that case wasn't neutral. So the court has this whole discussion about how it only applies to plaintiffs who sue the government, and so that's not neutral as the court.
Yeah, but that's not what, I mean, I'm looking at the analysis in Felder, and it, as you said subsequently, it's a direct preemption case. It says that the notice of claim statute undermines the uniquely federal remedy that is Section 1983 in several interrelated ways. And then it talks about 3 ways, one of which is that it conditions the right of recovery that Congress has authorized. The second is that it discriminates against the federal right. And the third is that it looks like an exhaustion requirement. All right? But really, the reason it's preempted is because it undermines the federal right. And it seems to me that Alabama's law is doing all of those 3 interrelated things. So I don't understand why we care whether or not it's jurisdictional or whether or not it's neutral in any given sense. It's doing what Felder says you can't do because it undermines the federal right.
So I agree the court doesn't have to care about any of that stuff. In fact, there is language in Felder that says that even if a rule is neutral and procedural, it's still, if it undermines the federal right, it's still preempted, and we'd be perfectly fine if the court went in that direction. I don't think it's neutral and procedural, but I'm sorry, Your Honor.
But do you contest the principle that state courts are generally completely free to define the jurisdiction of their courts?
No, I don't contest that general principle.
But there are some exceptions, right?
Yes.
So why isn't that body of case law the appropriate body of case law to apply here, since the Alabama Supreme Court tells us that this rule is jurisdictional? We presumably have to accept that. This is a matter of state court jurisdiction. So why don't we look to the body of case law that explains when this general rule that the state courts can define the jurisdiction of their own courts gives way? I know you want to talk about Patsy and Felder, but why is that neither of those involves jurisdiction?
That's right. So this court has upheld some jurisdictional rules and struck down others, and we're happy to talk about those cases. So in Howlett and most recently in Haywood, this court held that jurisdictional rules were preempted. And in both those cases, the rule of decision was that the state courts in general hear 1983 claims, and the state courts sometimes hear claims against these particular defendants. And so the state cannot avoid preemption just by defining the jurisdiction of the state courts to exclude cases where this defense is asserted. And in fact, in the Howlett case, there's actually this language that says that Felder would not have come out the other way if Wisconsin had said that state courts lack jurisdiction over claims in which the notice of claim requirement wasn't satisfied.
Well, in Haywood, the court concluded that the New York rule evinced hostility toward 1983. Can that be said here when the Alabama courts will entertain the 1983 claim? It's just a question of when they will do it.
Well, I think that maybe hostility is too strong a word, but I think the state has a policy disagreement with Congress over the merit of hearing unexhausted claims. Respondent's brief emphasizes that Alabama made the policy judgment that exhaustion is a good idea, it really helps the claimant, and that's a policy judgment that is inconsistent with the policy judgment that Congress made when it enacted Section 1983 without an exhaustion requirement.
You have a broad argument, Mr. Unikowski, that if it's an exhaustion requirement, it can't get in the way of a lawsuit. You also have a narrower argument that has to do with this case. But what would be, if you had to define a narrower class of cases that are preempted, so that if we wanted to avoid the question of whether all whether all exhaustion requirements were preempted, what would that narrower class of cases look like, and what justifies the parameters?
So I think the court could say that it's not going to rule on whether all exhaustion requirements are preempted, but it's going to say that this particular statute is preempted as applied to all 1983 claims, and that holding would avoid looking at the facts of this particular case. And I think the court could reach that conclusion by comparing the time limits here to the time limits in Felder. So in Felder, the court held that the statute undermined Section 1983 because the claimant only had 120 days to bring the suit, and therefore the practical effect of the notice of claim statute was to immunize the state against many types of 1983 claims. And so I think, this case, the time limits are actually much shorter. It's 7 days from receipt or 15 days from mailing of a decision to file an internal appeal to the appeals tribunal. It's also 15 days to go to the Board of Appeals. One of the petitioners in this case alleges that he couldn't appeal because that entire period came and went when he was in the hospital on a ventilator because of COVID. So I think that the court can hold that this particular statute has the same type of adverse effects on claimants as...
So it would be a line about the degree of burden that's attached to the 1983 right?
That's right. That could go in that direction, because that was part of Felder's reasoning, and so I think the court could incorporate that.
I mean, it was part of Felder's reasoning. Felder has some language that suggests a very broad rule applying to all exhaustion requirements, but then it also goes into the time limits. It has a lot to do with how much burden there is on the 1983 right, and it also discusses the purposes of the statute and whether those purposes suggest a conflict with the policy of 1983. And the relationship between or among all of those things is not particularly clear from the language of the opinion. Sort of suggests that they don't really believe that there's an absolute bar when it comes to exhaustion requirements. Do you agree with that? Do you have any, views about the relationship among those three aspects of the court's reasoning?
Yeah, I'm not sure I agree with that, because I think the reason there were so many different arguments in Felder was that it wasn't really clear that was an exhaustion requirement in the typical way of you file your claim to the agency, you wait for a couple of years, you're trapped in purgatory, and then you leave the agency, right? Because it was just a notice of claim requirement. You just submit your claim, and if you wait a particular period and they haven't answered, you get to sue. And in fact, in the part of the opinion talking about exhaustion and Patsy, the court says, well, the state says it's de minimis, implying that, maybe some exhaustion requirements fall under Patsy, but this just isn't one. And the court says, no, this really looks like an exhaustion requirement. But because of that dispute, I think the court felt the need to go through all of the other doctrinal machinery. I think this exhaustion requirement is exactly like the ones in Patsy. It's an absolutely classic exhaustion requirement. You go to the agency, you have to wait for it to rule. As this case illustrates, you might have to wait for several years before getting a chance to go to court. And so I think Patsy's reasoning that this is just not an affirmative defense to a Section 1983 claim carries over to this case.
Mr. Unikowski, how, we've said in our own context about jurisdiction, it's a term of many, many meetings, too many. How are we supposed to, let's say I agree with you that the definition of jurisdiction has to be a federal one. How are we supposed to decide? Because a different test does apply, right? If this is a jurisdictional requirement than if it's just a straight up, more Felder-like scheme. So what is the test? How do we decide if a state rule is really jurisdictional or not?
So the words of this court's cases, which I'm sure Your Honor knows very well, was that it's really jurisdictional if it reflects concerns over the power over the person or competence over the subject matter that jurisdictional rules are designed to protect. I certainly understand that that formulation will not resolve any or even many cases, but I think that just looking at how the courts in Howlett and Haywood reached their conclusions, so in both cases the court held that, number one, the state courts have general jurisdiction over 1983 claims. Number two, the state courts in general had authority over these defendants as long as certain other conditions were satisfied. So, for example, in Haywood, the court emphasizes that you can get injunctive relief against these defendants. And so the court said, well, if there's power over 1983 claims in general, power over these defendants in general, the rule is not a bona fide jurisdictional rule. I think that's the reasoning in those cases. And again, carried over to this case, I think you'd have the same reasoning. Alabama courts generally have jurisdiction over Section 1983 claims. There's jurisdiction over this defendant as long as the claim is exhausted. There's jurisdiction over unexhausted claims when there is no exhaustion requirement in the particular scheme. All that's happening here is that the state is cutting out from jurisdiction claims in which the defendant has this particular affirmative defense, even though this court has held that that's not a defense under Section 1983. And so I don't think the court really has to elaborate the exact lines here. The lines are a little bit blurry, but I think that, as applied to these particular facts, you can
it's like a claims processing rule.
Right, exactly. So, I mean, I think there's going to be a lot of borderline cases, but I don't think this is one.
And let me just ask you one question about how this scheme works, because I agree it's very odd. Is there some mechanism when you're before this intermediate tribunal where you actually fill out a piece of paper and say, I'm asserting a due process claim in addition to my claim for benefits? How would one even exhaust the due process portion of this?
So I've been wondering that too. I mean, maybe you can just go back right now to the appeals tribunal and file a 28J letter saying, hey, enough time has passed. There's a due process violation. I don't know if there's any procedural mechanism to do that I'm aware of, but that does seem to be what the state court is requiring here.
I came into this case thinking that perhaps there wasn't a great deal at stake, since a plaintiff like your plaintiffs could always file in federal court and avoid the exhaustion requirement by doing that. But what you just said in response to Justice Barrett makes me think that this could be much more important, because if we are going to read into the general rule that state courts can define their jurisdiction, what we have done in determining whether federal statutes are jurisdictional, which is pretty much to say, boy, it's really hard for us to conclude that anything is jurisdictional, then you are really asking for a significant weakening of this general rule, which has been a landmark rule for hundreds of years.
So I'm not sure the court should engage in the sort of statutory interpretation of state statutes that it would engage in for federal statutes. That's not the rule we're asking for. All right, we're not quarreling with the state court that as a matter of state law, this is a jurisdictional statute.
Okay, fine.
Okay? What we're just saying is that not all jurisdictional rules are created alike for purposes of federal law, and that distinction might sort of match the jurisdictional versus claim processing type of distinction that this court has articulated.
Okay.
And are you saying that, assuming this is a state jurisdictional rule, it cannot or can be preempted? I thought this case was about preemption, not about the characterization of the state law. So if we agree and assume that the state law is jurisdictional, what implication for whether or not it can be preempted by federal law?
In this case, I think there's no implications. It's preempted regardless of whether it's jurisdictional.
Why?
Because this court has held, as far back as the Mondu case in 1912, that a state court cannot decline jurisdiction over a federal claim because of a disagreement with a federal policy allowing the claim to proceed. And I think that's what's happening in this case. Alabama has the view that exhaustion is a good idea, and it has imposed that by statute. But Congress has decided that that's not the case, that you should be able to bring 1983 claims without having to exhaust. And so
so it's a supremacy clause issue in terms of whether or not that has to be the outcome.
Yeah, I think the rule of decision applied by the state court in this case is inconsistent with the rule of decision that Section 1983 requires the state court to adopt. So I think there's just direct preemption in that way. We're not disagreeing with the purposes and objectives analysis in Felder. We agree with that too, but I think there's an even more straightforward way to get to the same outcome.
Put aside Felder, what is the problem with just going to federal court?
Well, we could have gone to federal court, but there's a lot of cases from this court. I won't mention Felder, but there's a lot of other cases.
What is the real-world problem with just going to federal court? Or maybe there aren't any, and you're just saying precedent says we can go to state court. But do you have any real-world problems with just going to federal court?
I think there's a lot of reasons that you would want to go to state court. So first of all, the Pennhurst Doctrine sometimes prohibits plaintiffs from bringing state law claims in federal court. Federal courts also often have abstention doctrines that prohibit bringing the claim in federal court. There's a brief from two religious freedom organizations that talks about the abstention doctrines in some detail. Also, there's practical concerns, like in some cases, lawyers would just be more familiar with the local state court. The vast majority of unemployment insurance litigation in Alabama happens in state court. And so if a lawyer may be more familiar with that tribunal, they may spend their entire career practicing in state court. And if they have a civil rights claim from a claimant, then it makes sense for them to go to state court.
And you mentioned this earlier, but a procedural due process claim usually requires that you go through the state processes first. Maybe that's how this case got on the wrong track. Do you agree with that?
In general, yes. I think that if you went to federal court and asserted your due process claim without exhausting, you'd usually lose, except in an unusual case like this where you're actually challenging the inability to exhaust.
Thank you, counsel. I want to make sure I have your complete answer to the line of questioning I understood Justice Kagan to be pursuing. And I think why you called this Kafkaesque, which is because you're being told you have to go to the state. Your claim is the state doesn't handle these things in a timely fashion. They lose the papers. You can't answer the phone. So why send them back? If you have to go back there, that's your whole point is you can't go back there because they do that's what you're challenging. And I just want to make sure if you had the most efficient state procedure imaginable. They answer the phone on the first ring, and they quickly give you a decision. Would your argument be the same, that it doesn't matter?
It would be the same. We would definitely lose in that scenario, but it would be the same argument that you wouldn't have to exhaust. So if such a claim was filed...
You would lose? In other words...
On the merits we would lose.
You would not, then the ruling would be you do have to go to the state before pursuing your 1983 action? The state agency?
So we don't think there should ever be an exhaustion requirement. If you filed a suit in federal court and said, even though they answered on the first ring, they should have been even faster, there wouldn't be an exhaustion problem. The federal court would just say there's no due process violation. It's a great state agency. It's very effective. And we just want the state court to apply the same rule of decision, right? You don't have to exhaust, but your claim loses because you're getting plenty of process.
Okay, well then what was Kafkaesque about the process? I understood you to say that was the problem, that it imposed a burden on the exercise of your federal right.
No, what was Kafkaesque is the ruling that we couldn't challenge our inability to exhaust precisely because we haven't exhausted. That was the problem. The problem was we can't exhaust effectively, and the state court held that because you didn't exhaust, you can't challenge that.
What if you can exhaust effectively?
Well, then you wouldn't have a claim. I mean, the problem is, as applied to this fact pattern, I think it doesn't make sense to apply an exhaustion requirement, and that's why we think that as applied, effectively, what the statute is doing is granting the state immunity in the state courts.
Okay, and my last question, you say as applied to this fact pattern.
Yes.
So tell me what the particulars of this fact pattern are that may not be the case in other situations.
The particulars of this fact pattern is when the petitioners are challenging their failure to exhaust, and they're told they can't challenge their failure to exhaust until they have in fact exhausted. The problem with that is that as a practical matter, you're immunizing the state in the state court from the 1983 claim because you can't exhaust. So you're incapable of challenging your inability to exhaust because the state is saying you have to exhaust until you can bring the challenge. So there's no way to challenge in state court at all. And so it's a de facto immunity akin to the immunities that were in the Haywood and the Howlett case. So that's our narrowest argument on this.
Thank you, Counsel. Justice Thomas? Justice Alito?
Could you have sought mandamus in state court to get a ruling in these cases, an administrative ruling in these cases?
So there's a dictum that is cited by a respondent from a 1997 intermediate appellate court case that says that in principle mandamus could be available if an agency intentionally sits on a claim and drags its feet, but no mandamus claim was asserted there. I think mandamus wouldn't be very effective in this case for a few reasons. So first of all, of course, you have to show a clear and indisputable right to the writ, which is a higher standard than in an ordinary civil case. Also, the only thing the state court could do is tell the state agency to rule, couldn't enter the other remedies that we're seeking in this case. Mandamus is also a discretionary remedy, and so I just don't think it's an effective substitute for the 1983 claims we're asserting today.
What if a state has a regime under which the person seeking the benefits first has to file the claim, and then there are two levels of appellate review, administrative review, and after, I assume that you would admit that if the case were filed in federal court, the person would have to seek the benefits in the first instance, right?
Yes, they wouldn't have to. It wouldn't be an exhaustion problem under Patsy.
No.
They'd have to seek the benefits because there's no violation if you haven't tried the benefits.
All right, and then the person says, "Oh, this process is too long. I want a quick decision. They've denied my claim." Then what?
So
it's a violation of my due process rights because this is more elaborate than it needs to be.
So if your claim was denied, you can go to federal court and you can file your claim and you can say there was a due process violation, and the court would adjudicate that. If you jumped the gun and didn't wait for all the process to wrap up, then probably the federal court would say that there's no due process problem. The state's giving you plenty of process. And we'd want the state court to reach the same ruling. And if that's not the case, if you were collaterally attacking the state court administrative process and you finished it and there was still due process violation, then maybe you'd win in federal court. And if you'd win in federal court, you should win in state court too. We're just asking to align the rules.
Thank you.
Justice Sotomayor?
Counsel, you say this is not a neutral rule because in every other case where there's a due process violation of an agency's process in some way, people can go directly to state court, correct?
That's one reason it's not neutral, and another reason is Felder's reason, which is that it only applies to plaintiffs who sue the government.
Plaintiffs who sue the governments for this particular type of benefit.
Right.
So it is sui generis to just one class of plaintiffs on one potential constitutional violation.
That's right. It does apply it does apply to state law claims. I acknowledge that, but it's not neutral in the sense that it doesn't apply in private tort litigation. It doesn't apply to other lawsuits against the government.
I guess I'm having trouble with the jurisdictional argument that my colleagues are concerned about. This is not jurisdictional in the sense of we're telling state courts that they can't hear a claim, correct?
I agree with that, Your Honor.
All right. We're not saying this is a federal claim, so it has to go to federal court. We're saying, no, you state courts have the power to hear 1983 constitutional claims that your legislature permits you to do. So it's not as if they're filed a neutral rule that says you can't hear 1983 claims, correct?
I agree, Your Honor.
And so all we're saying is you state courts should decide in the first instance whether there is a due process violation, correct?
That's correct. We're not saying in this court that we necessarily deserve to win. We just want a chance to be heard.
Justice Kagan?
In the colloquy that you had with the Chief Justice, you started with the broad form of your argument and ended up with a narrower form, a much narrower form. In the delta between the two, it seems to me you're going to lose on the merits anyway. In other words, if somebody goes in and says, I got $100, I really deserve $200, they didn't listen to a certain category of evidence, that's a due process violation. You know, you've not made the argument, they're just going to throw you out, whether it's you call it on the merits or because your claim isn't ripe. So why should we go to the broad form of the argument when nobody's going to win in that category of cases anyhow?
I guess I just think that's the cleanest reading of Felder. I mean, Felder has lots of different rationales, and I think all those rationales apply to exhaustion requirements in general, or even more narrowly, all those rationales apply to this statute whenever it's applied. So the court could go narrow. I just don't see a way of distinguishing Felder from any other case in which the exhaustion requirement is invoked. But, you know, if the court rules in our favor narrowly, obviously that's fine from our perspective.
Thank you.
Justice Gorsuch?
This new narrow theory, what exactly does it encompass? What class of cases?
So the narrowest argument that I've articulated is when there's a de facto immunity from the application of the rule, then there's a preemption problem.
When it's impossible to exhaust, is that another way of saying it?
Well, when the very thing you're challenging is your failure to exhaust, then the state can't say you failed to exhaust, because once you've exhausted, then your claim goes away because you've exhausted, it becomes moot at that point. So essentially, you're immunizing the state from these claims that there's a due process violation in connection with the exhaustion procedure.
I'm not sure I've got it, but let me try. That it's impossible to bring your claim.
Yeah, I think applying this rule, it's impossible to challenge the exhaustion requirement in state court. Yes.
Okay. And what if it's not impossible here because of mandamus, because you might have a futility argument? We just don't know. Then what?
So I don't think respondent has argued in favor of a futility argument.
Well, I think all of this is kind of new, to be honest with you, this narrow theory. I read your brief as pressing the broad theory, but here we are. Let's say we just don't know whether it is truly impossible here. What do we do then?
Well, even if it's not truly...
Putting aside your broad theory.
No, I understand, Your Honor. Even if it's not truly impossible, I still think that at least it puts a significant condition in front of the vindication of the claim that's no less significant than the condition in the Felder case.
What if they're the same sorts of conditions that exist in the federal administrative realm when we were dealing with a federal benefit and an agency doesn't rule? I'd make a futility argument and I'd maybe mandamus the agency.
I guess I think Section 1983 is a special statute. This court held, Patsy, that there's no exhaustion requirement. There's immediate access to a judicial forum. So I just think that's different from the mine run case in which you're challenging a decision from the Social Security Agency.
Thank you.
Justice Kavanaugh? Justice Barrett?
I just want to clarify your answer to Justice Gorsuch. He asked you to stick to the narrow theory, but to answer you reverted to the broad one, that Patsy just precludes exhaustion requirements generally. If we do not agree with your reading of Patsy, can you try one more time to articulate that narrow theory that doesn't rely on Patsy?
Sure. I would say that there is a significant barrier to the vindication of a claim challenging the inability to exhaust a remedy when the court holds that you have to exhaust a remedy in order to bring that claim. I mean, what we're trying to do is get the state agency to give us hearings and give us adequate notice. And what the state court said is that because you didn't exhaust those remedies, precisely because we didn't get the hearing and the notice, you can't bring your claim. So even if Justice Gorsuch is correct that there's some theoretical way with mandamus, which we don't think this is an adequate substitute to bring the claim, I mean, there's still a very significant barrier, which is to the bringing of the claim. So, that does place the type of barrier that I think would conflict with Congress's objectives when it enacted Section 1983.
Okay, thanks.
Justice Jackson? Thank you, counsel. Mr. LaCour?
Mr. Chief Justice, and may it please the Court. This Court finds historic state powers to be preempted only when the text of federal law makes that result clear. Nothing in 42 U.S.C. Section 1983 makes clear that it was meant to preempt neutral jurisdictional rules like the one at issue here. Petitioner's reliance on Patsy ignores the key difference between exhaustion rules created by Congress and exhaustion doctrines crafted by courts. The former may preempt, but the latter do not. They are judge-made timing rules like ripeness and abstention. They do not add elements to a federal right, but merely determine when a federal court is going to hear it. This Court's ripeness and abstention holdings do not apply to state courts, nor does its determination that federal courts generally should not send 1983 plaintiffs to the states. Precedent confirms that 1983 does not contain a categorical no-exhaustion element. In Johnson v. Fenkel, the Court did not require immediate appellate review of a 1983 defense. In Ohio Civil Rights Commission v. Dayton Christian Schools from 1986, this Court applied younger abstention to force a 1983 plaintiff back into state agency proceedings. These decisions show that deferring consideration of a federal right does not necessarily alter or defeat it. Thus, while some notice of claims rules, like the one in Felder, are preempted as obstacles to adjudication and liability, agency review is typically a means of adjudication and does not inherently conflict with 1983's remedial purpose. But even if immediate judicial consideration were an unwritten element of 1983, neutral jurisdictional rules like Alabama's are still a valid excuse for declining jurisdiction. Reading 1983 to preempt such laws would raise serious constitutional questions that are best avoided. I welcome the Court's questions.
Well, Mr. Unikowski's argument, as I understand it, is that the exhaustion rules in Alabama makes it impossible for him to pursue the due process claims that he has under 1983. So would you respond to that?
Yes, Your Honor. 2 points. One, as Justice Gorsuch was alluding to, that is a new argument that was not presented to the Alabama Supreme Court. It was not passed upon by the Alabama Supreme Court. It's not in the cert petition, and it's not properly before this Court. Their only argument is that even the most perfect agency adjudication, if it has an exhaustion rule, is preempted. And we think that, as Justice Kagan was alluding to with Felder, that rule has already been rejected by this Court. But looking at this as applied challenge to Alabama's law, we don't think that it is the case that it functions as an immunity. Mandamus is still available. There is still the potential for a futility argument, one that was not raised below. And so it's simply not the case that it is impossible to get an adjudication here.
I'm not sure how it is possible, given that, as I read the Court's decision below, you have to bring the due process argument to the agency, and I don't see any procedure to do that within the agency. There's no mandamus within the agency. I don't know how the mandamus court would have jurisdiction because it requires exhaustion. So you're in a loop that I'm not sure how this claimant gets out of.
Your Honor, I don't think mandamus would require exhaustion. The point of mandamus would be to break the sort of log jam that plaintiffs are complaining about here, but they didn't take advantage of mandamus.
Alabama ruled very broadly. It didn't say that Mr. Williams, for example, who had a final judgment that he was attacking, had a claim that could be heard in court, and you seem to concede in your briefs that he did. He got his claim thrown out because he didn't file the notice of claim. Then he brought a due process argument saying that the notice he received was inadequate or the time limits were not proper under due process. And the Alabama court dismissed his action as unexhausted. That sounds to me as if the due process claim has to be exhausted within the agency.
Well, Your Honor, if he had exhausted it and it was final, he had the ability to file a direct appeal to the circuit court.
He did.
No, Your Honor.
And the court did what it did, and all of a sudden he goes up to the Alabama Supreme Court and dismisses it as unexhausted.
Your Honor, I think it's important to remember how this was actually litigated before the state courts. Their primary argument, if you go back to their briefs before the state courts, was that this exhaustion requirement didn't apply to sort of procedural challenges whatsoever. There was no 1983
please just tell
claim.
me what form, where is it in this process that tells litigants, if we're not acting, you can go to the appeals council and file something and get them to order the agency to do something. And then if the agency doesn't do it, maybe you've exhausted and you have a futility argument to go seek mandamus or to go do something in state court. This is a Kafkaesque type of process that's going on here.
I don't think so. Alabama case law makes clear that mandamus is available and that you may be able to raise futility arguments.
It's discretionary mandamus, isn't it?
Correct, but we presume that state courts are going to follow the federal
I actually
Constitution.
don't know how mandamus operates with respect to the exhaustion requirement.
Well, and that just points out the waiver problems that I was addressing earlier. None of this was briefed up below. None of this was argued in the blue brief either. And so what we are dealing with here is this categorical rule, and we don't think that even Patsy supports this categorical
General,
rule.
on that question, you started today, but with the text of federal law does not preempt. And that's a fair argument and a good argument. It's just the argument that was in the dissent in Felder. Justice O'Connor made exactly those same points, but it was a dissent in Felder, and in the majority in Felder, it made clear that the exhaustion requirement by Wisconsin's law was problematic. It said it doesn't involve lengthy or expensive administrative proceedings, but it forces injured persons to seek satisfaction from those alleged to have caused the injury in the first place. Such a dispute resolution system may have much to commend it, but that is a judgment the current Congress must make. In other words, the language in Felder does seem, contra Justice O'Connor's dissent, the language in the majority in Felder does seem to suggest that exhaustion requirements generally, and we can talk about how to define those, but generally are preempted even though there's no text.
A few things on that point, Your Honor. First is Felder did not just say Patsy ruled and then in a two-page opinion end the case. There was a detailed, nearly 15-page preemption analysis there. And the court made clear there were really two key problems with the Wisconsin law. One was that in purpose and effect it minimized liability. And so there's your clear conflict. You have a federal law designed to impose liability and a state law designed to minimize it. I think that is the through line from Felder to Howlett to Haywood, is those are immunity laws. Then second, the court said that the law in Wisconsin frequently and predictably defeated the 1983 claim. Now, defeat means that you're going to exercise jurisdiction over it and then dismiss it with prejudice because it is an affirmative defense that the defendants were handed by Wisconsin, and that did result in dismissals with prejudice. A jurisdiction, like the law at issue in Alabama, jurisdiction is not an affirmative defense. You would never say that an amount of controversy requirement is an affirmative defense, and it doesn't defeat the right. It simply says we're not going to consider it. And so there's no way for Alabama to alter the 1983 right by merely defining jurisdiction over it.
Counsel, I appreciate that summary of what Felder said, but in the section on page 141 where it talks about what it means to undermine for preemption purposes, it first of all has three things, not just two, and the three things aren't just minimizing liability and defeating the 1983 claim. It says it conditions the right of recovery that Congress has authorized and does so for a reason manifestly inconsistent with the purposes of the federal statute. So that's one thing. And I appreciate that it to minimize government liability, but the point is that it's inconsistent with the purposes of the federal statute. Second, the notice provision discriminates against the federal right, and it talks about the differences in the time limits in a way that discriminates. And then finally, it operates in part as an exhaustion requirement. Now, I appreciate that your counsel on the other side is just homing in on the exhaustion requirement, but Felder seems to take it even beyond that. So can you explain why Alabama's law is not doing the three things that mattered in Felder to the preemption analysis?
Yes. So agency adjudication is not a means of minimizing liability. It is a means of adjudicating whether or not claimants are entitled to money. I think that's far different from the notice of claims requirement in Felder, which had no benefit whatsoever to plaintiffs. Unlike here, the exhaustion requirement in Alabama law can be beneficial to plaintiffs because it keeps their well-heeled employers or the secretary from taking them to court
Right, but can you
immediately.
talk about the purposes of the federal statute, right?
Yes,
because I understood preemption to be about inconsistency with the reasons or the goals the federal statute was there. So isn't a requirement like Alabama's, which prohibits the ability to bring a due process claim under these circumstances, inconsistent with Section 1983, which is supposed to be giving people the ability to make these kinds of claims?
Oh, Your Honor, we're not prohibiting anyone from bringing them. You get to raise those very claims in front of the agency first, and I think that's a key difference between—
But not if the agency won't process your papers.
Well, and Your Honor, that's why we have mandamus. That's why the futility arguments are present as well. And then second, there's a key difference between going to an agency for an adjudication and just being forced to go park your claim for 120 days with the police officers who purportedly beat you up, the law issue in Felder. Again, that in no way can benefit plaintiffs, but the exhaustion requirement can benefit plaintiffs. And also, my friend is incorrect. The exhaustion requirement does apply to the secretary as it applies to claimants as well.
So your argument at bottom is that this is consistent with Congress's objectives in 1983, because I understood that to be the sort of umbrella consideration with respect to preemption, which is what I thought we were talking about here.
Yes, I don't see any conflict with the way Alabama has structured judicial administration and with the purposes of 1983, which are to impose liability. This is not a liability minimizing scheme. It was not designed to do that. It was invented in 1935 to make unemployment benefits available to people. No one would think that—
Has anybody ever recovered in 1983 making these kinds of claims in Alabama state court that you're aware of?
Your Honor, I'm not aware. I've not seen one cited by my friends, and I've not found one myself. But I don't think anyone would say that the Social Security Administration is set up as an obstacle to people who are trying to get disability benefits. It is the avenue for getting that, and it's the same thing with labor.
Ask about the dimensions of your argument in two different ways. I'll give you just a couple of hypotheticals. So one is, suppose we take this out of the employment context. We're not talking about a benefit of any kind. There's a person who has like a quintessential 1983 claim, which is the improper use of police force. And Alabama sets up a scheme where you have to go to the police department first, and you have to go through these 3 levels of review before you can bring that to court. Is that perfectly okay, or does that change matters?
I think, Your Honor, if we're talking about case by case, then I think it's time to affirm the Alabama Supreme Court's decision because it was just this categorical argument. But second, to get to your question, you need to look to see, does this look like a rule of judicial administration or not? It may be looking a lot more like Felder and thus might be more suspect. But
I don't understand. What makes it more suspect?
Well, it might be who is it that's doing the adjudication? What are the sort of requirements that bind them?
Yeah, I mean, it's sort of set up the same way, but it's a police board. You know, police officers are on these boards, and they make you go through three different stages, and we make you do all that for police boards of different levels before you can take the claim to court.
Your Honor, again, if particularly stringent, you might run into some problems like in the Brown case from 1949. If it looks like it's designed to minimize liability, you might run into some Felder problems.
Well, if. Let's just say it's the same kind of thing, but it's in the police context. It's the same time limits. It's the same everything. There's no piece of paper that says we're doing this to prevent good claims. You know, but it's in a different context, a non-benefits context, a quintessential 1983 context.
The court has said in Howlett and Haywood that neutral rules of judicial administration are a valid excuse for refusing to entertain a federal claim. So if that is a valid and jurisdictional rule that's been set up, then I think that would be okay.
Why wouldn't that look an awful lot like Haywood itself? A rule that evinces hostility to the 1983 claim, because there's no tradition of requiring this sort of thing when a plaintiff wants to bring a classic Fourth Amendment 1983 claim.
Well, I think that history could factor in, but at the same time in Haywood, there was no way to get into state court whatsoever. I took it in Justice Kagan's hypothetical that you would get to court eventually to raise your claim. And this court has said, I think this court's rulings show that merely deferring consideration of a claim is very different than defeating it. So look at Johnson v. Fenkel, where you had a 1983 defense of qualified immunity that was denied at summary judgment stage in the Idaho trial court. And they wanted to take that up immediately to the Idaho Supreme Court, and were not able to do so. And 1983 did not give them some right of interlocutory appeal. And I think that's essentially what petitioners are asking for here, is a right of interlocutory appeal. I don't want to
derail. Justice Kagan, I think, had a number of hypotheticals, but so I don't want to interrupt that. But then eventually I do want to ask you about Mr. Unikowski's narrow argument. Did you want
to? It doesn't matter which way we do it.
I'm not sure I can capture exactly what his narrow argument is, but suppose the narrow argument is that there's no exhaustion requirement in a 1983 case in state court where it is, as a practical matter, impossible or extraordinarily onerous to get a decision. How would the state be hurt by that? What would be wrong with that?
I think there might still be some sovereignty interest if you're going to be reading the statute to require state courts to exercise jurisdiction that the state has never given them jurisdiction to exercise. And that's why the court has been careful, even in Haywood, to say that these neutral and truly jurisdictional rules are a valid excuse for declining jurisdiction. That's the nature of any jurisdictional rule that's going to keep some cases out of court, so that can't be the test.
But couldn't it be, though, that in some of those cases, at least, where it's truly impossible and it really is a catch-22, that is evincing hostility to the plaintiff's claims, and a Felder argument might be made there?
Absolutely, or even a Haywood argument.
Or even a Haywood argument. We just don't know whether that's the case here.
Right.
Yeah. All right.
How about if, in Felder, there is a lot of talk about the time limits. Here, the time limits are even more stringent than they were in Felder. Suppose we make them even more stringent still, and let's add another bunch of things. Let's say that instead of 3 levels of review, there are 5 levels of review. Let's say between each level, you have to proceed within 5 days, and then you have to bring your court claim at the very end within 5 days. Let's say we have empirical evidence that suggests that because the state administrative process is very slow, it takes an average of 10 years to actually get to court. At that point, can we say that this is so onerous a process that it has to be in conflict with 1983?
Your Honor, that sounds like it could fall under Haywood and potentially be in conflict with 1983 under a Haywood theory, even if it is a truly jurisdictional rule that starts to look like an evasion rather than something that's really about the competence over the subject matter. But here, this truly is about competence over the subject matter. You have an expert agency. Like, since these claims existed for the first time in 1935, they've always been adjudicated in the first instance by these hearing officers. They have expertise when it comes to hearing these types of claims because they hear thousands or hundreds of thousands a year. They're applying the statutes and regs again and again. And it's the exact sort of situation that this court confronted in Elgin v. Department of Treasury, a Thunder Basin case about the Merit Systems Protection Board, where the court recognized that the MSPB has certain expertise because they hear these personnel claims.
But the expertise is in adjudicating the entitlement to unemployment, not the due process claim, right?
Your Honor, a similar argument was made in Elgin that the MSPB doesn't typically hear constitutional claims. And what the court recognized was, well, no, they are going to hear some similar types of claims that are going to come up again and again in this context. For example, it's not fair because I didn't get my notice on time, therefore excuse my lack of filing the appeal. And then that can be considered by the Board of Appeals, or the Appeals Tribunal, or the Circuit Court eventually.
So tell me, and this is just the clarifying question I was trying to ask Mr. Unikowski, how does one assert these due process claims, say, before the intermediate tribunal? Is there a mechanism for doing that? It just seems like everything that was a description in the briefs was talking about how to pursue getting your unemployment benefit. How does one go about making this due process argument before the agency?
Your Honor, my understanding is it's a fairly informal process. So I think it would be as simple as arguing that this is not fair because the notice was ineffective, for example. But again, ultimately, that issue was not thoroughly briefed because that wasn't the argument they were pressing before the state Supreme Court.
You're making your position seem benign, but we have amicus briefs from a wide variety of groups, from ACLU and Public Citizen to religious liberty groups to the Chamber of Commerce, all of which say that your rule will really hinder federal civil rights claims from getting into state court. The religious liberty plaintiffs say that your position would grind religious litigants into submission before they are able to have their claims heard in court. We see the same thing from the ACLU's brief. You want to respond to that?
Yeah, no, I think this court's precedents in cases like Felder and Haywood help to guard against that. Plus, if
don't they guard against it by saying that exhaustion is not a requirement before you bring a 1983 suit in state court?
No, Felder, again, did not deal with an agency adjudication. It dealt with a law that said, park your claim here for 4 months, and then, and if you don't do that, you have an affirmative defense you're going to be facing, and you're going to lose, which I think is far different.
But just to pause there, your answer suggests that I'm misreading Felder. Every state Supreme Court that has considered the issue, I think, before the Alabama Supreme Court has read it just the way I just said.
Your Honor, I think South Dakota was on our side, and then in some of those cases you were dealing with.
The vast majority of state Supreme Courts.
We're definitely on the short side of the split, but we understand.
And the short side of the split is because those state Supreme Courts almost uniformly have read Felder to mean you can't have exhaustion requirements. Very simple rule. You can't have exhaustion requirements for 1983 in federal or state court. And you have a good argument to the contrary. The problem is it's in the O'Connor dissent, not in the majority in Felder.
Your Honor, again, I think you have to read those statements from Felder in their context. I mean, of course, opinions are not statutes, but if they were, I'd invoke the presumption against superfluity. There's a lot more in Felder to suggest that what was really the problem was that it was trying to minimize liability, and there the conflict couldn't be clear with 1983. But I cannot find in the text or in Patsy this categorical no exhaustion rule, and I don't see how you square that with cases like Ohio Civil Rights Commission, which I mentioned in my opening, and I apologize it's not in the briefs, but it's a 1986 decision where this court applied younger abstention to a 1983 claim to force that claimant back into a state agency proceeding. Dayton Christian Schools had fired a teacher on religious grounds, sort of a precursor to Hosanna Tabor. The teacher went to the Civil Rights Commission and said this was based on sex, and the commission opened an investigation. That 1983 plaintiff went to federal court and said, we have a free exercise right to be free from these state proceedings altogether. And an opinion by then Justice Rehnquist, the court said no, take it up in the state agency, which again shows that deferring consideration does not defeat. And it also suggests that my friend's position would lead to very strange outcomes where a federal court in Ohio did not have to hear that particular 1983 claim, but a state court would have to, and that just simply doesn't add up. And I think that gets to the other point.
Just one more. You've invoked federalism and respect for states, but I think the practical effect of your rule, if we were to adopt it, would be everyone or most people would go more quickly to federal court and haul the state before federal court. The irony of that. Can you comment on that?
I don't think so, Your Honor. I don't think there's an incentive for states to structure their courts in a way that's necessarily going to send everything to federal court. If they do, then so be it. But at the same time, that might be an incentive.
Well, these kinds of claims, if you had problems, you know, a free exercise problem, a religion problem, or a procedural due process problem with the unemployment scheme in Alabama, you're just going to go to federal court.
Right, and as Mr. Yudkowsky acknowledged, you'll lose on the merits. So I don't think that's going to be a serious problem here for Alabama.
That's the point of suppressing the federal right in state court, isn't it? If you make the hoops so difficult to go through, then they have no remedy. Here, Mr. Williams was thrown out of the state process because he didn't receive notice, because he was unconscious because of COVID. And he's had no remedy in their state court. So basically what you're really saying is, no, we're not hostile to a federal right because we know we're going to win no matter what we do.
Your Honor, I think...
And one last question. Tell me where in your regulations there is a process set out that claimants can go through to speed up the process. All of them have told me that they've appealed on time. They've called not all of them, but we have 21 plaintiffs here. Many of them filed their appeal notices, letter after letter, phone call after phone call, years and years that passed before they received anything, or when they received something with no explanation. So tell me where in your regulations you tell claimants what they can do before the agency if there's a due process violation.
Your Honor, I don't have chapter and verse for you because, again,
you can provide a letter. I don't want to hear about mandamus, or I want to hear where in the regulations these people didn't do what the regulations said they could have done.
Your Honor, mandamus is not something they're required to do, but it is something that is available to them.
And it's discretionary, correct?
Counsel.
Yes, Your Honor, but it is one way to avoid due process problems.
Counsel, can I just... go ahead.
No, go ahead.
Can I just get you to focus in quickly on Felder? And you've said many times that you see that case as the problem being about minimizing liability. But I'm quoting from the case when it says that this is, quote, essentially, the question is essentially one of preemption. Is the application of the state's law to Section 1983 actions brought in state courts consistent with the goals of the federal civil rights laws? Or does the enforcement of such a requirement instead stand as an obstacle to the accomplishment and execution of the full purposes of the objectives of Congress? I thought we were thinking about, is it an obstacle? Is it consistent? And what I'm worried about is that if we start moving away from that conception of what it means to be preempted, that same kind of thought process and doctrine is used in other laws, not just 1983. For example, we have the Federal Arbitration Act, which has a preemption standard that is almost identical to what Felder just said about whether or not it's consistent. And we've repeatedly said that state laws that do things like, related to contracts, et cetera, are preempted by the FAA for the very same reasons. So can you help us not to be concerned about shifting the standard of what it means to preempt and the way in which that might actually implicate other preemption doctrines in other laws?
Your Honor, I think the real concern would be adopting the view of preemption from my friend, which doesn't really seem to line up with the more disciplined and text-based approach that this court traditionally takes.
No, we can let's say we reject saying there's something about Felder that is focused on exhaustion. I'm looking at Felder as a preemption case that has a standard that talks about the inconsistency with the purposes of the federal statute. Mm-hmm. Is it an obstacle to the accomplishment and execution? And I got to tell you, in the Concepcion case, in AT&T versus Mobility, that exact same concept is governing what the court is doing with respect to preemption. So if we move from that, if we're focused more on minimizing liability or whatever else you say you think Felder means, I'm worried that that's going to bleed over into these other kinds of preemption areas.
Your Honor, what I'd say to that is, why was the law an obstacle? And the text answers that question. State officials shall be liable. What's the state law do? Minimizes liability. So there is your text-based preemption problem right there on the face of the statute.
It's not in the text of the statute. Minimizing liability is not in
Correct, but the law at issue there was part of a broader liability scheme. The Felder Court recognized this. That was enacted after Wisconsin had done away with judicial immunity. The Wisconsin Supreme Court had done away with judicial immunity, and so this new immunity statute was enacted that had damages caps and also had this notice of claims requirement. Wisconsin extolled this as a way to minimize liability, so there wasn't really a question as to what the law was doing. But
the plaintiffs here could have brought suit immediately in federal court, is that right?
Yes, Your Honor.
So, I mean, this is Felder's, it seems to me there's a lot going on in Felder, but one, its most essential holding is it quotes Patsy, and it says, Patsy said, too bad about an exhaustion requirement. You have to be able to bring suit in federal court immediately. And then, and this is on page 147, it says, should there be any different rule with respect to state courts? And it says, given the evil at which the federal civil rights legislation was aimed, there's simply no reason to suppose that Congress meant to have that kind of distinction. So, I mean, that seems just like a very clear-cut understanding of Felder, that once we say that the exhaustion requirement does not preclude suit in state courts, we understand 1980, it does not preclude suit in federal court. We understand 1983 to do the same thing with respect to state courts.
Your Honor, even if I grant you that, this is still a jurisdictional rule, and you've still said in Howlett and Haywood that neutral jurisdictional rules are a valid excuse to keeping federal claims out. So even if there is some get to court immediately element of 1983, our courts do not exercise jurisdiction over that type of claim.
Thank you.
Thank you, counsel. Justice Thomas, anything further? Ms. Alito? Justice Sotomayor? Okay.
Your friend on the other side said if it went to federal court, there might be a rightness issue and an abstention issue. What are your thoughts?
I think that is, I think that's likely true. We've seen that in a lot of courts of appeals decisions. We've cited Cotton v. Jackson as I think it's a 2011 circuit decision where they lost on the merits for not taking advantage of the process and running to federal court too soon.
Okay.
So,
and I take your point that, as I understand it, your argument is it's hard for this to be an exhaustion requirement of administrative agency processes to be an obstacle that's improper, given that the federal government has similar administrative exhaustion requirements. But there does seem to be a tremendous record of difficulty of individuals accessing that administrative process here. What assurance do you have, or can you give us, that the state is addressing these claims in a proper and timely manner?
yes, Your Honor, 2 points. The reason we point to the federal analog is to show that this really does concern competence over the subject matter, like the court has discussed in Howlett.
Due to COVID or
Absolutely, Your Honor. I think 1 million additional unemployment claims. And then, of course, when you have COVID, it makes it harder to hire people and makes it harder to retain people, too, during the height of the pandemic.
Thank you.
Mrs. Kavanaugh? Justice Barrett?
I asked Mr. Unikowski about the state statute of limitations, so I'm going to ask you the same question. When does the state statute of limitations start running on these claims? And to clarify, my concern is if somehow the state statute of limitations is running, because the due process violation has already begun in the agency, is it the case that that statute of limitations might run in state for purposes of state court before they can even get there?
Your Honor, of course, this hasn't been briefed. I don't think that would be an issue because the due process violation isn't complete until the process has run out. So I think, and certainly if they were to appeal.
Brief, you called the agency proceeding a proper proceeding for redress under 1983, and you said there's no reason for this court to distinguish between bringing a 1983 claim in something that's called a court versus sending it to an agency. Is that somehow different than the exhaustion requirement? Can you just...
Your Honor, our point there is that we think the language suggests that there is a great deal of discretion for the states in terms of structuring their adjudicatory processes. And in this instance, we have the agency first functioning sort of as an adjunct. They compile a useful record that can then go up for the circuit court to review with de novo review. And that's particularly helpful for uncounseled claimants who maybe don't have a lot of means because they just lost their job. They can go through this informal process, have a record. They don't have to go through formal discovery and have a lawyer to have that record when they do get to the circuit court.
So is the argument, I mean, I guess I'm trying to distinguish between an exhaustion requirement, which is almost kind of like a pregame thing, you know, it's a threshold. And this makes it sound like if you're saying this is part of the 1983 claim itself or part of the adjudication, it's actually not a delay of the 1983 claim, but is your argument instead?
Thank you, Your Honor. I just wanted to clarify one answer I gave to Justice Gorsuch about ripeness. I did acknowledge that ripeness is in general a defense that a federal court can vindicate in a Section 1983 case. I wasn't trying to suggest that in this particular case, if we went to federal court, there would be a ripeness defense. I think we've waited long enough and our claim is ripe. So it was more a general point about federal court's powers to dismiss cases. I'd like to say a couple of words about the Felder case. There's a lot of discussion this morning about whether or not exhaustion was an independent holding or whether the decision was partly based on exhaustion, partly on other considerations. Even if the latter formulation is correct, I actually think that every single consideration in Felder also applies to this case. It's true that Felder talked about whether the state was trying to minimize liability, and my colleague said that the agency system in general wasn't trying to minimize liability. I don't think that's the question. I think the question is whether the exhaustion requirement in particular is trying to minimize liability. I think the answer has to be yes. The sole function of the exhaustion requirement is to cause claims to be dismissed when they're brought in circuit court. And because the time limits are so tight, claims are going to be predictably dismissed a lot more frequently than the notice of claim requirement at issue in Wisconsin, and so in the Felder case. And so ultimately, I think every single consideration in Felder really applies with equal force to this case. So the court doesn't need to parse out which aspects of the holding we're holding and which were alternative holdings, which were dicta, because I think the entire decision applies to this fact pattern. On the question of jurisdictional rules, I think the court would really have to overrule a lot of cases dating back to 1912 to vindicate the argument that this is a jurisdictional argument that can survive preemption. I think it's notable that the amicus brief by several states actually does advocate overruling all these cases back to 1912. Respondent doesn't ask for that, and I think if the court keeps those cases, then the result in this case follows. As far back as 1912, the court said that state court cannot decline jurisdiction based on disagreement with the policy judgment of Congress that a defense is unavailable, and that's simply the principle we're asking to carry forward today. Finally, on this as-applied challenge, I just wanted to point out that in the proceedings below, immediately after asserting our argument based on Patsy, we said it would be absurd to make us wait for years in the administrative process and then bring our claims, which I think is reasonably construed as the same type of as-applied argument we're making this morning. And we did make this argument in the blue brief as well as the yellow brief. So I do think it's teed up for the court's consideration. If there's no further questions, we'd ask the court to reverse.
Thank you, counsel. The case is submitted. We'll hear argument next in case 23677, Royal Canin versus Wolschlager. Ms. Wellington.
Mr. Chief Justice, and may it please the court, the Eighth Circuit's decision below is an extreme outlier. It conflicts with the text and structure of Section 1367 and with more than a century of precedent. Chief Justice Marshall held in Mullen against Torrance in 1824 that in a diversity case, a federal court's jurisdiction, once vested, cannot be divested by subsequent events. The court extended that reasoning to removal actions in Kirby against American Soda in 1904. And in 1938, this court held in St. Paul Mercury that if the plaintiff, after removal, amends his pleadings, this does not deprive the district court of jurisdiction because the defendant's statutory right to removal should not be subject to the plaintiff's caprice. The second Justice Marshall confirmed that conclusion in Carnegie Mellon against Cohill in 1988, and Justice Scalia concurred in Rockwell in 2007. Respondents asked this court to upset that settled interpretation, claiming that it conflicts with the text of Section 1367. But Congress codified this court's longstanding precedent in the text of Section 1367 itself, making clear that if the federal court has original jurisdiction, it shall continue to have supplemental jurisdiction unless Congress expressly provided otherwise. Respondents cannot cite a single decision of this court, a single decision of a court of appeals outside of the Eighth Circuit, or a single treatise that supports their position. Respondents realize how weak their case is and instead ask the court to decide something else, whether Grable should be overruled and if so expressly provided otherwise. And then to figure out, what does Section 1367 say about Rule 23 and plaintiffs and class actions? And the court looked at Section 1367, said it doesn't say anything about Rule 23, and that means that there is supplemental jurisdiction. There are also some important structural inferences here. So Section 1367(c)(3) makes clear that where the district court has dismissed all claims over which it has original jurisdiction, it can continue to exercise supplemental jurisdiction. And that really disposes of the argument that there has to be an ongoing federal question in the case in order for supplemental jurisdiction to be warranted. Congress didn't intend that here.
So do you think, Ms. Wellington, that let's say this wasn't a removal case, let's say this was an original case and it was brought in federal court, and then the plaintiff took out the federal claim, leaving only state claims, is there supplemental jurisdiction there?
So this court has treated these two situations differently, and Justice Scalia explained why in Rockwell. So there's a concern in Rockwell that when a plaintiff goes into federal court, pleads a federal question, and then immediately or subsequently drops it, that they're trying to plead their way into federal court.
So forgetting what the reason for that is, you do agree with that rule that once I file a suit in federal court as an original matter, then take out the federal claims, leaving only state law claims. There's nothing at that point for the federal court to do. It's not a doctrine of discretion anymore. The federal court has to dismiss. Is that correct?
That is how we have asked this court to read Rockwell. The U.S. Chamber of Commerce brief,
I just want to make sure.
That is our view.
So if that's the case, I don't think that your arguments from 1367 can be right, because your arguments from 1367 would suggest the opposite result in the case that I gave. In other words, it's very hard to read 1367 as imposing some kind of distinction between original cases and removed cases.
So I agree, Your Honor, that there is no distinction in the text of 1367 itself. This court could revisit its decision in Rockwell or limit it to the FCA context. We haven't asked the court to do that because we think that we win on the text here. We think if you just—
I guess what it suggests to me, though, is if you were willing to say, look, the Rockwell understanding of original cases is settled, we're not contesting that, then I think your arguments from 1367 go away, because 1367 just doesn't create the kind of distinction that you're asking us to create. So either you lose as to removed cases too, or these arguments from the text are just not going to get us to your result.
So we disagree, Your Honor, with your interpretation of the text of Section 1367. We think Congress has made clear that there is supplemental jurisdiction unless Congress has expressly provided otherwise. It hasn't done that. And I think it's very important to consider how Congress came to write Section 1367. It was in response to Finley, where this court took an extremely narrow view of pendant claim and pendant party jurisdiction in particular, and Congress said, no, that's not what we want. We want a broader view of pendant claim and pendant party jurisdiction, and that's why they wrote this very broad statute here. And it would be very strange to conclude that Congress intended to abrogate Cohill, was decided just 2 years before it enacted—
That's the point, isn't it?
Sorry, go ahead.
That's the point, isn't it? I can't get over the fact that what Congress did in 1367 was address the questions that had been in the court. The first one was the diversity issue under St. Paul, and it agreed with the court. It disagreed with the court on pendant and supplemental jurisdiction, and it wrote a statute to address that. And yet it knew from Cahill that we had said that if a plaintiff dismisses an action, that potentially we go back to the original amendment, and it didn't do what it did for diversity. It wrote it to say only when the district court dismisses the federal claims do you retain supplemental jurisdiction. That, to me, is the statute. They had all our case law. They addressed one thing they agreed with. They disagreed with another, and they disagreed with the third by not adopting what it did with diversity.
So 2 responses, Your Honor. First, Section 3C2 does expressly address this Cahill situation. It says the district courts may decline to exercise supplemental jurisdiction when the state law claim substantially predominates.
When the district court has dismissed all claims. It doesn't say when the plaintiff has dismissed all claims.
So I agree. That's C3.
And when the district court dismisses all federal claims, the party still has a right to appeal, correct?
That's correct.
When the district court doesn't do that in a diverse action, then that, because the claim has disappeared, there's no appeal for the for anybody, correct?
I think, Your Honor, it depends on the case. I think there could still be an appeal in a diversity case where the district court dismisses a claim and the plaintiff says you shouldn't have dismissed that claim.
No, but that's because they're there because of the diversity provision of this statute.
Can I just understand your argument about whether or not an amendment can affect federal question jurisdiction? So setting aside diversity for a second, we're in federal question land. The case is filed in federal court, and the plaintiff goes through the first couple weeks and then says, you know what, I'm dropping my federal claims because it originally brought a complaint that had federal and state claims. Does that affect jurisdiction in your view or not?
And this is a case originally brought in federal
court, and the plaintiff amends and takes out the federal claims. Can the court proceed? Can it decide through supplemental jurisdiction or whatnot to continue on with the case?
So this court suggested in Rockwell that the answer to that would be no, you would not continue in that case. And
okay. So, next question. The case is brought in state court, and it has federal and state claims, and before the defendant has the ability to remove, the plaintiff says, oops, I didn't mean to bring the federal claims, I'm dropping them. So no removal action yet or motion yet. Can it be still removed? Is there any basis for federal jurisdiction in that situation?
No, Your Honor.
All right. So it seems to me then your argument comes down to the impact of removal, because somehow, even though in a situation in which the plaintiff amends if it was brought originally in federal court or amends if it's brought originally in state court, those have an impact, you say, on federal question jurisdiction. Somehow, if the defendant removes before the plaintiff can drop the federal claims, you say no impact on federal question jurisdiction. Is that right?
That's correct.
Why?
So this court explained in St. Paul Mercury that once you've removed to federal court, there is a removal statute and the defendants have a right to remove.
But the removal statute doesn't say, as I think Justice Sotomayor was trying to get at, anything about what happens to jurisdiction. I thought the removal statute was really just giving the defendant the ability to bring this action into federal court. It doesn't say anything about whether or not the federal court can be divested of jurisdiction once it's there, and I don't understand why the federal court can be divested of jurisdiction if it starts in federal court, because the plaintiff brought it there, but can't be divested of jurisdiction if it comes to federal court because the defendant brought it there.
And just to be clear, the rule that we're asking for and the rule that this court has applied for 100 years is that it's a matter of discretion once you get to federal court on removal. It's up to the district court
on removal,
judge.
But I guess why does it make a difference as to how this case landed in federal court as to whether or not the federal judge can be divested of his jurisdiction? That's what your argument seems to turn on, and I don't know why that's the case.
And this court addressed that in St. Paul Mercury and said that the defendant's right to remove should not be subject to the plaintiff's caprice. Congress gave defendants rights in the situation when the case gets to federal court on removal. That's different than when a case is
It changes the scope of jurisdiction. The removal right carries with it the ability to affect the jurisdiction of the court, is what you're saying.
That's what this court has long held in cases like St. Paul Mercury and Cohill. The court recognized that in Rockwell. It also recognized it in cases like Carlsbad, where this court was talking about Cohill remands and determined that they were not mandatory, that they were a matter of discretion for the district court. And I agree, Your Honor, that in most cases the outcome is going to be the same. When you get to federal court on a removal case, you drop your federal claim immediately. Most of the time you're going to go right back to state court. It's going to be the same outcome. Where it matters are cases like this one, where the case has been going on for almost 2 years when they amend their claims. We've cited other cases where it's been pending in federal court for a long time, and right before an adverse decision, so that's on page 16 of our yellow brief, right before an adverse decision, the plaintiff amends their complaint to try to get back to state court. And in that situation, district courts have said, well, I'm going to balance this attempt at gamesmanship with other considerations like—
Counsel, can I interrupt you there? I mean, St. Paul Mercury is a little bit different because it's diversity, and there's always been a problem, you know, when I used to teach diversity jurisdiction, in the amount in controversy and figuring out how to value it. And you're not capped to the damages that you claim, and so there wasn't a real change there. And, you know, Cohill, okay, it's helpful, but it's really about a different point. It's about dismissal versus remand. I think the best thing for you are all these Court of Appeals cases. I mean, I have a lot of trouble with the textual argument for the reasons Justice Kagan is saying, but I mean, it does give me some pause to say, oh, all these Courts of Appeals have thought this was okay, and there is that footnote in Rockwell. But it's not quite the old soil principle, because the old soil principle requires you to be able to hang your hat on something in the statute and say this is what brought along the old soil with it. So you cite Taggart and the old soil principle, but what are you attaching it to, as opposed to just some sort of like free-floating, everyone thought we could do this?
So we totally agree, Your Honor. It has to be important that for decades and decades and decades, every Court of Appeals has gone the same way. We disagree, Your Honor, that Cohill didn't address this question. It does say that when a federal law claim is eliminated at an early stage of the litigation, the district court has a powerful reason to choose.
To choose, it's dicta. It's dicta. Just go with my old soil question.
So I think it is important here that Congress whole swath took parts of Gibbs and Cohill and the lower court cases prior to the enactment of the statute. So Section A, as well as Section C, 2 and 3 are word for word from Gibbs. The top part of Section C, the district court may decline to exercise supplemental jurisdiction, that's drawn directly from Cohill. And C1, where it talks about the claim raises a novel or complex issue of state law, that comes from 1980s Court of Appeals decisions that took that into account when determining whether to exercise supplemental jurisdiction. So this
Your briefing obviously suggests, at least at the outset, you don't think Grable has much to do with this case. And your friend on the other side obviously disagrees. But I wonder why it doesn't. I mean, your reading, I think, assumes the correctness of your position under 1367, that this complaint is one over which the district court would have original jurisdiction. And your friend, I think, has concluded that depends upon whether Grable is correct. And so why doesn't it depend upon Grable?
So this court can decide jurisdictional issues in any order. That's what it held in Sinochem. We agree that there has to be an adjudication of the Grable question in order to get to the ultimate, remedy in this case, but that's not what we're asking this court to decide. So we don't think the court has to decide the issue. If the court wants to decide the issue, we think there plainly was jurisdiction based on the original complaint. The original complaint repeatedly claims that there are violations of the Food, Drug, and Cosmetic Act, and then in paragraphs 136 and 137 of the complaint asks for an injunction requiring ongoing compliance with federal law.
Well, the original complaint, but not the removed complaint. In other words, not the complaint with all the federal things stripped out of it. In that situation, if that's the one you look at, then Grable is critical to your success, I think.
Just to be clear, so the complaint at the time of removal had a federal claim. You know, that's our position. I think Your Honor is talking about supplemental jurisdiction.
Yes, of course.
And this court has long held that you don't have to have a federal question at all stages of the case in order to exercise supplemental jurisdiction. That's exactly what the court held in Rosado, where the original federal claim became moot. And this court said that the three-judge district court could continue to go on and decide the ancillary claims, even though it didn't have original jurisdiction, because you don't have to have jurisdiction over the original federal claim through all proceedings.
In 2007, in Rockwell, in footnote 6, the statement there resolves this case in your favor, footnote 6. Now, the other side's going to say a lot of things about footnote 6. I think that it's dicta, that it's mistaken, that it's wrong, that it should be ditched. You want to just take on footnote 6 because you win with footnote 6, but
so
you know, do we stick with that?
We think footnote 6 is not dicta. We think it's actually quite essential to answering the question that Justice Jackson was asking. Why do we treat these two circumstances differently? And you have to remember, prior to Rockwell, this court had not addressed cases that were originally filed in federal court. So this court was trying to explain, we have 100 years where we do something different in the removal context. Why are we going to do something different here? And Justice Scalia was explaining the different policy concerns. So we don't think that's dicta. We actually think it is essential to the reasoning in that case. And even if you think it isn't a holding, it certainly is recognizing that this court has resolved the question in the removal context going all the way back to—
And why is it correct? Assuming, why is it correct? In other words, it does seem, as Justice Kagan's questions indicate, that the Rockwell above the line and the Rockwell footnote, you would think, would come out the same way under the text of the statute. So I guess, assuming the above the line part is correct, why does the text of the statute support footnote 6?
So I think the text of the statute supports the removal jurisdiction in this case, not what happened in Rockwell. So
Right. So I think your answer is the part of Rockwell that's not in the footnote is shaky.
That's correct, and that's what the Chamber of
Part
Commerce—
in the footnote, you think that's solid?
I think that's solid because the text of Section 1367 says there is supplemental jurisdiction unless Congress has expressly provided otherwise. Section C3 makes clear that you don't have to have a federal question throughout the proceedings in order for there to continue to be supplemental jurisdiction. C2 expressly addresses situations like this one, where the federal law claims have fallen out. In that situation, the state law claims would substantially predominate.
I think they're going to probably say something also like it was stray comments that weren't carefully considered, and you want to respond to I'm just previewing what they're likely to say. Yeah.
One thing I do want to emphasize here is this court was thinking about this question in Cohill. If you go to the oral argument in Cohill, right around minute 5, Justice Scalia is asking the same questions that we're talking about today. So the court wasn't somehow unaware of this question.
You seem to be articulating the position in the oral argument, as I read it, that Judge Strauss ultimately came to in the Eighth Circuit, but obviously by the time of Rockwell, Justice Scalia had not stuck with that.
I think that's right, and I think it is important that this court was aware of the question, continued to apply its precedent, its longstanding precedent in Cohill, and I don't think you can write Cohill, which is all about this is a doctrine of discretion. I don't think you can write Cohill if you think that the court didn't have jurisdiction.
So can we go back to first? Go ahead.
Suppose a diversity case. I have a diversity case. I file it in state court. It's removed to federal court. And once I'm in federal court, I join a non-diverse party. Can the federal court hold on to that case?
So no, Your Honor, and that is addressed specifically in 1367B. So there are circumstances, for example, where there's a third-party defendant or a dispensable plaintiff under Rule 20 that, the court may be able to because it's not addressed in Section...
Yeah, well, why should there be a different rule regarding parties and claims?
So Congress thought very hard about this. This court has long had two different lines of precedent, one for pendent claim jurisdiction and one for pendent party jurisdiction. Has taken a very broad view to pendent claim jurisdiction and a very narrow view to pendent party jurisdiction. And Congress said, that's not what we want. We don't want Finley. We do want some limits. I think B tells you that A is so broadly written that if you don't have B, that there would be concerns about diversity jurisdiction questions, Your Honor, but Congress thought very carefully about this, and it made clear that there would continue to be supplemental jurisdiction even when the federal claims dropped out of the case.
If we thought that the Eighth Circuit's decision is right as a matter of first principle, what relevance, if any, would this line of Court of Appeals decisions have in our decision-making?
I think it's very important here because Congress is codifying precedent. It's codifying these Court of Appeals decisions in particular in C1. It's very much aware of them. And the Court of Appeals decisions are reflecting this court's decision in St. Paul Mercury and Cohill and now Rockwell. This is incredibly well established. So I don't think the court should ignore that that's what the Court of Appeals have been doing and that they're doing it for a reason. Because this is a doctrine of discretion, it's a matter for the district court to say, what are the fairness concerns? What are the comity concerns? What are the judicial efficiency concerns? Maybe the district court can dispose of the state law questions really easily, and the case has been going on for 2 years in the district court. It doesn't make sense to send that case back to state court.
Well, this goes back to a question that Justice Barrett asked. Usually when we apply this old soil rule, we're talking about a term of art in the statute about which there was a body of pre-existing precedent. What term of art can you point to here that supports your argument?
Sure. So if you look at C, the district courts may decline to exercise supplemental jurisdiction. That language comes directly from Cohill. It's not in Gibbs. That's the language the court uses twice. And so when you're thinking about what did Congress intend to codify, when it comes to whether the district court can exercise discretion, I think you have to take into account what this court held in Cohill. I also think, Your Honor, if you think that the text doesn't say anything, this court has held that statutory silence implies ratification by Congress. I think you can apply that doctrine as well to reach the answer here.
I think if you think that the text doesn't say anything, you're left with trying to figure out what rule to use in this instance that best coheres with the whole panoply of rules that we use in other contexts. And I think that on that account, you have a tough road to hoe. You have St. Paul, and that's the amount in controversy. But for the reasons that Justice Barrett said, the amount in controversy requirement has generally been thought of as sui generis because of the difficulty of figuring out when, how you're supposed to measure that. But otherwise, I think that the rule basically is we look to the operative complaint. We look to the original complaint when the original complaint is operative, but once the complaint has been amended, we look to the amended complaint because that's the operative complaint. And that's why you can create diversity jurisdiction or destroy diversity jurisdiction by adding and removing parties. And it's also why you can, add, it's also what explains Rockwell. And it also explains how you can add and remove federal claims to create or get rid of federal question jurisdiction. So you're asking for a very kind of unique rule where it's like, no, we don't look to the operative complaint. We look to this old complaint that has nothing to do with the case anymore.
May I respond, Your Honor?
Certainly.
So I think it's very important here that this is a longstanding rule that really reflects the idea that Congress wanted district courts to make the decision. They wanted district courts to decide, Is there gamesmanship going on here? Is there judicial efficiency concerns? Are there comedy concerns? And this rule that this court is talking about would need to apply to all sorts of different circumstances, such as when the claims become moot, when the parties settle the claim, when the plaintiff amends the complaint. And when Congress drafted Section 1367C, what it wanted was to give district courts discretion, and that's a reflection of decades and decades of precedent, Your Honor.
Thank you. Thank you, counsel. Just a brief question. You complain about the forum manipulation problems this would create. I don't see how that's a problem here. They started in state court. They want to go back to state court. They're not trying to manipulate anything.
So we think that it is forum manipulation, particularly in this case where they waited almost 2 years to amend the complaint after they lose in the Eighth Circuit. We think that's a form of forum manipulation. We think there are much more extreme forms of forum manipulation. For example, where a plaintiff, the district court says, I'm about to rule against you. That's what happened in 3 cases on page 16 of the yellow brief. And the plaintiff says, great, send me back to state court. And that's a very serious form of forum manipulation. But we agree, Your Honor, in many cases, the mine run of cases, you get to federal court, you immediately amend the complaint. The federal judge is going to send that back to state court. We're really talking about the more unique circumstances like this one where it's been going on for a long time, and Congress wanted district courts to consider different considerations.
Thank you. Justice Thomas?
Justice Sotomayor asked you about what happens when a judge dismisses some of the federal claims, and you responded to that. And she was referring to C3, and which only refers to the district court dismissing those claims. It says, but C3 says nothing about the instance in which the party amends the complaint and eliminates the federal claims. Would you address that?
Certainly. That's a really important point. So that is addressed in C2. So in C2, where there is no longer a federal claim, the state claim will substantially predominate. It could also fall under C4, an exceptional circumstance. I would point out, Your Honor, that C is simply listing when district courts may decline to exercise supplemental jurisdiction. This court in ExxonMobil against Alipata said really the key question is it in the statute? And certainly amendments to the complaint is not in the statute, so we think that's sufficient. But if you want to look at the text of C2, I think that also answers the question.
But do you agree that when the district court dismisses the claim, it remains in the case?
I agree, Your Honor, but that is also true of an amended complaint. You can appeal whether a complaint was properly amended. We cited the Lucente case in the Second Circuit that reinstates the original complaint on appeal. So if that's the test, we think that's met.
But do we normally think of a complaint that's amended by the party to eliminate a federal claim as still having that claim?
I think that's true of all these circumstances where the claim becomes moot, where the parties settle, where the plaintiff voluntarily amends, where the district court dismisses. Those claims for the purposes of the party aren't going to continue to be litigated. We think the important question here is when do you evaluate whether there is an original federal question in the case. Under this court's longstanding precedent going all the way back to St. Paul Mercury, you look at the time of removal, Your Honor.
So when does an amended complaint supersede the earlier complaint?
Your Honor, we don't think that's the right question. The question isn't whether it supersedes the original complaint. The question is, at the time of removal, is there an original federal question in the case? We think that's what the phrase "in the action" is doing. If you look directly at Gibbs, which is where that language came from, Gibbs is saying what you need is the original claim and the supplemental claim to be in the same case. That's true regardless of whether the complaint is amended. That claim was filed in the same case.
Justice Alito?
When many courts of appeals have considered a question and they've all decided it the same way, that certainly requires very respectful consideration. They are very likely correct. But would you also recognize that there can be circumstances in which there can be sort of a snowball effect in busy courts of appeals, particularly on a certain category of issues, so that if a court of appeals decides a question one way, then the next one just latches onto that, and pretty soon courts of appeals confronting an issue are very likely to say, wow, if all these other circuits have gone this way, I'm not going to create a conflict in the circuits on this. I'm just going to go along with it. Do you think that's a dynamic that can occur in courts of appeals, and if so, should we take it into account?
I think that's possible, Your Honor, but I think this is a pretty unique case. We searched high and low, and the only two cases we found that went the other way was one district court case from 1915 and one district court case from 1940. That is overwhelming precedent in the courts of appeals. And if you look at cases like Bolins, which is a case that Justice Scalia cited in Rockwell from the Fifth Circuit, it very carefully explains the reasoning of why we treat these two circumstances differently. I think you also have to look at this court's precedents. Cases like International College of Surgeons, Rosado, Carlsbad, Osborne against Haley, all of those cases are suggesting that this is a doctrine of discretion. So this court has been giving the lower federal courts the same signal for many, many decades of this is how we're going to treat this situation, and we think that's what Congress codified in the text of Section 1367.
Well, do you think that courts of appeals read our decisions differently than we may? I mean, I was on a court of appeals for 15 years. If I saw a strong dictum in a Supreme Court decision, I would very likely just salute and move on. But here, we have more of an obligation. It depends, Justice Sotomayor. Both when we're considering, when we're considering what we've written, we know how these things are written. We know how these footnotes are written. Do we have liberty to read them a little bit differently?
Of course, the court has the liberty to read its footnotes how it would like, but I do think it is important to keep in mind here that the question is, what did Congress intend? Congress enacted this statute in reaction to the court's very narrow view of supplemental jurisdiction in Finley. It adopted very broad language, and I think it would be very weird to think that Congress intended to abrogate Cohill silently without saying anything about it. And I think it would also be strange to treat the situation where the plaintiff amends the complaint differently than a situation where it becomes moot, where it drops out of the case for some other reason, such as settlement. I think then you'd have to get into the Eighth Circuit's decision between involuntary and voluntary amendments.
Thank you.
Justice Sotomayor?
I go back to Congress knew when to adopt or not adopt a particular circuit court reading, and it didn't do anything with 1367, but it did do with diversity to codify that. So I don't know how much the old soil counts. But let's go back to first principles. What's the justification for this? Plaintiff manipulation, correct?
It's much broader than that, Your Honor. So judicial efficiency is a very important reason why Congress enacted the Gibbs principles into Section 1367. So a case may be pending for 2 or 3 years. The district court might be really familiar with it. It might be a really straightforward question of state law. In that situation—
So how doesn't Rule 15 take care of that? It gives plaintiffs a narrow window to amend, and otherwise it needs to seek permission. So why didn't the district court simply deny permission here?
This case was pending almost 2 years before the amendment was made, but it was still an amendment as of right in this case, so you can have an amendment.
It wasn't within the window permitted by the rule.
It was, Your Honor, because the case went up on appeal and came down. So there are situations like that. But there's also, leave to amend should be freely given under Rule 15. That's not really the kind of standard that takes into account these judicial efficiency, comedy.
Certainly does. I mean, that's the entire purpose of the freedom of the power and discretion to amend. So I just think as a matter of first principles, it's really, you have an amici with the Center for Litigation and Courts who supports your argument, but says don't rely on that. And I think they make that point for a reason. It's not your strongest point, and then I don't understand why we should change all the other rules that respect an amended complaint as the complaint setting forth the claims in an action?
Your Honor, we think if you were to rule for the other side, that would be upsetting 100 years of precedent, every single Court of Appeals decisions. That would be changing the rules. All we ask this Court to do here is apply settled law.
Justice Kagan? Justice Gorsuch?
We've talked a lot about 1367, but I'm not sure we've paid much attention yet to 1447. And I can certainly see the argument that the operative complaint should be the one at the time of removal under the old version of 1447, which suggests that a case should be remanded if it was improvidently removed. That does seem to focus the Court's attention on the complaint at the time of removal. And I think a lot of the Court of Appeals kind of been operating under that kind of idea of the rule, but it's been amended. And it now reads that a case should be remanded if at any time it appears that the district court lacks subject matter jurisdiction, which, you know, just reading that one might, and I'm sure we're going to hear this argument, so I wanted to give you a chance to respond to it before you sit down, that focuses the Court's attention on the then operative complaint. Thoughts?
Two responses, Your Honor. So I think it's important to keep in mind that the 1911 version of the statute, the predecessor of 1447 that was in effect during St. Paul Mercury, had basically the same text as it did today.
I grant you that. And then it went to was improvidently removed for a very long time. And now it's come back to looking more directly at the then operative complaint, doesn't it?
So I think it is important that this Court reached the ruling that it did in St. Paul Mercury under the old text. I think that suggests that it...
I grant you that with respect to the amount in controversy, and we've been around that tree a few times. So putting aside that point, you got anything else you want to say about it?
Certainly. So they didn't make that argument in the red brief because it doesn't answer the question. The question is whether the federal court has jurisdiction or not. We think that's answered at the time of removal. And this court in the Wisconsin Department of Corrections case said that Section 1447 was merely procedural. It did not affect the district court's jurisdiction. So I think you would have to revisit that case in order to read 1447 here the way you suggest.
Ms. Kavanaugh?
Just want to make sure on the state of the law, and maybe following up on Justice Kagan's question, because you would think when you pick this up, if you were uninitiated, that there'd be a standard rule. Look at the complaint at the time of filing or removal, or look at the complaint at the time of amendment. But at least as I looked at everything, it's just a mess, right? There's just boxes everywhere where, you know, in the diversity context, destroying diversity almost always compels dismissal or remand, but reducing the amount in controversy or changing citizenship of a party almost never does, right? Is that correct?
That's correct, Your Honor.
Like Morgan's heirs and St. Paul Mercury on the one hand, then own equipment on the other. There's no logic connecting those things, at least as I see it. They're just rules out there without connective logic. There might be, each box has its own little idiosyncratic policy considerations, but there's no connective rule, at least as I read it. Correct me if I'm wrong.
I think you're right.
Or the other side can correct me if I'm wrong, too. Yeah.
I think you're right, Your Honor, that there are different rules that apply in different circumstances, that they have different policy concerns or longstanding prudential concerns, and that this court shouldn't go around disrupting those rules. There are lots of different rules that apply with respect to adding diverse parties. Sometimes you can do that, sometimes you can't. You can add a non-diverse successor in interest, for example. So there's lots of different circumstances, and we simply ask the court to apply settled law. We don't think the court has to come up with a unifying theory for all these different areas of the law. Congress acted with an important reason here with respect to supplemental jurisdiction. It wanted to protect the defendant's right to remove, and I think that's why you see this broad text here, and as well as judicial efficiency. So,
and by settled law, you mean footnote 6, you mean Cohill, or what are you referring to there?
So you're right, Your Honor. So St. Paul Mercury, Cohill, and Rockwell. There are also cases like Carlsbad where this court expressly asked, is a Cohill remand, that's the phrase the court used, is a Cohill remand discretionary? I don't think this court could answer the question yes without having again decided this question. There are other cases like International College of Surgeons and Rosado that again emphasize that this is a discretionary question. And I don't think this court should just depart from all of that precedent here. I don't think there's a good reason to, and this court should, this is a statutory question. Stare decisis carries enhanced force in the statutory context, and that's why we've asked the court to continue to apply settled law.
Thank you.
Justice Jackson?
Just a couple of quick points. So you keep talking about protecting the defendant's prerogative of removal, but I thought there was also sort of basic principles about the plaintiff's prerogative to bring a case in state or federal court to be the master of their claims. And so what I don't understand is why the plaintiff has to be stuck with the jurisdictional consequences of claims they are no longer bringing. They've given up their ability to seek relief on the federal claims. And so it just seems odd to me, especially when our case law kind of generally links jurisdiction with the claim. You have to have jurisdiction for every claim. Those two concepts run together, and yet somehow they can drop claims and still be, in your view, subject to the jurisdictional consequences of that. That just seems discordant to me. So can you speak a little bit about that?
It's a really important question, Your Honor, because what Congress was trying to do is take into account the right of plaintiffs to be the master of their complaint, but also the right of defendants to remove. And that's exactly what investing discretion—
But Justice Gorsuch points to statutes that talk about remand. So even though the defendant has exercised its right of removal, there are circumstances in which that right is not given precedence. The case goes back to state court, right?
That's exactly right. It's up to the district court to decide. And we think in the mine run of cases where you amend the complaint right after you remove, there's removal to federal court, that's going to go back to state court. What we're really talking about here are more unusual cases where it's been going on for a long time. There may be particular concerns.
Can I just ask you about the text, moving quickly because I'm mindful of the time. I don't understand how the question could possibly be whether or not there is original jurisdiction at the time of removal. Of course there is. That's why the case gets to be removed. I mean, there's no question there that does any work because you only get to remove it if there's original jurisdiction. So isn't the question really what happens when, after we've identified original jurisdiction and it's removed, the claims over which there were original jurisdiction drop out? Can supplemental jurisdiction be exercised when those original jurisdiction claims are no longer there? When we look at the text of 1367, I don't understand your argument that supplemental jurisdiction arises in that situation because A says, in any civil action of which district courts have original jurisdiction, the district court shall have supplemental jurisdiction. But in my scenario, original jurisdiction is gone. So how can you have supplemental jurisdiction in a situation like this?
I think it's really important to go back to the first principles that this court was applying in Cohill. It was looking at St. Paul Mercury, which holds that you have original jurisdiction at a particular time. And so once you get original jurisdiction, you continue to have supplemental jurisdiction. That's what the court held in Rosado. There, the original claim became moot.
So what wouldn't we expect it to say in which the district court had original or ever had original jurisdiction? It seems to be in the present tense saying that you have to have original jurisdiction in order to exercise supplemental.
And I think that's because you have decades and decades of precedent saying that in a removal context, you look at whether there's jurisdiction at the time of removal. At that time, the district court has original jurisdiction, and then the question is, will it continue to have supplemental jurisdiction? The text here is framed in a forward-looking future tense. And we think shall have does cover the situation where there's ongoing supplemental jurisdiction.
Thank you.
Thank you, counsel. Mr. Keller?
Mr. Chief Justice, and may it please the court. The life of the law has not been logic. It has been experience. And experience should have taught us by now that a suit arises under the law that creates the cause of action. That should be the definitive test for arising under jurisdiction for at least 3 reasons. It's the most faithful to the text, it avoids serious constitutional problems, and it will save decades of pointless litigation over jurisdiction. Now, if you're not yet ready to re-embrace American Well Works, and it sounds like you might not be, I suspect that stare decisis does a fair bit of work, in which case stare decisis supplies an easy alternative path to affirm. This case is Merrill Dow, but for pets, not people. And while I take a backseat to nobody in my love of our 4-legged friends, I am confident Congress believed that misbranded human product was a more substantial federal issue than misbranded pet food. If we turn to which complaint controls, the 8th Circuit again should be affirmed. My friend and I crucially agree. The text of 1367 is dispositive here. And remarkably, we also agree. If this case were originally in federal court, it must be dismissed. Why? Because by amending out all of the federal issues, they're no longer in the action. If that's what the text of 1367 means for an original case, how can the exact same words take on a different meaning with removal? Despite my friend's professed commitment to textualism, she has no choice but to flee to public policy. We can't have these mischievous plaintiffs' lawyers shopping around for their judges, we're told. Now, that concern is not happening in the real world, and my friend's solution wouldn't solve the problem even if it were. But none of that matters. This court has said many times that text trumps policy. You merely need to say so once again in order to affirm. I welcome your questions.
Mr. Keller, would you spend a bit more time on the application of 1367 and how it supports your argument?
Of course, Your Honor. So I think the plain text controls, we agree about that. The present tense verbs, I think, are intended to indicate that there is jurisdiction presently. We focused on the word have with the colloquy with Justice Jackson. I would also focus on the word are. There has to be a relationship between the other claims, the state law claims, that are related to claims in the action, the federal claims that are within the court's original jurisdiction. If we amend out those federal claims, they're no longer in the action, there's no relationship, and so there's no supplemental jurisdiction. That's 1367A. That's the requirement to establish supplemental jurisdiction. You don't get to the exceptions in B or C unless you establish jurisdiction under A.
I think not logic but experience, you lose, Mr. Keller, because the experience cuts the other way. I mean, and this has all, until the 8th Circuit came along, the position of the petitioners has always been understood, assumed. Everybody thought that that was the rule. And it was a rule which really has no adverse consequences because everybody remands these cases anyway. In 99% of the cases, there's a remand. So, like, what harm is this rule doing? And this rule has existed in every single circuit court for these many years.
Yeah, so I respectfully disagree. The master principle that I think governs in every context except the amount in controversy is that the amended complaint controls. If you amend a complaint in state court to add a federal claim.
So I basically agree with you. I mean, I basically agree with you on that and not with Justice Kavanaugh. Justice Kavanaugh says it's all arbitrary. I don't think it's arbitrary. I think some of the cases that he was talking about is when facts in the world change. But when we're not talking about facts in the world, when we're talking about allegations, I think that the structure is the way you describe it, that we look to the operative complaint, the amended complaint, except in the amount in controversy area where there is sort of special considerations. But so I kind of agree with you that if we were creating a system where all the rules cohered, yours is the better rule. But I think on the other side of the table is, look, we have this anomalous rule, but this anomalous rule has been accepted by everybody for many, many years, and it does no harm anyway, since most of these cases are remanded back to state court where they belong.
Yeah, a couple of responses to that, Justice Kagan. First of all, I don't think that we, meaning this court, has ever embraced that rule. It's true that the lower courts deserve respectful consideration, but a lot of these cases predate binding statutory text, so I'm not sure that that's dispositive. Also, I would respectfully submit that you're the supervisory court that's most important in our Article III system, and when you're hearing a question for the first time, you ought to adjudicate it correctly, notwithstanding the respectful consideration that you would give to the lower courts. And if you've determined, as it sounds like you have, that from first principles I'm right, the fact that lower courts that obviously can't can't bind. This one got it wrong, I don't think is a reason to just say, let's go along to get along. And I also think there
Counselor,
are...
You're suggesting that it's kind of the first time the courts considered the question. I understand that, but you do have Cohill and the Rockwell footnote to deal with. And I haven't heard a word about those yet.
Well, here it comes, Justice Gorsuch.
I can't wait.
As Justice Kavanaugh previewed, I don't think that footnote 6 in Rockwell is anywhere near the ratio decidendi of the opinion. Justice Scalia was as capable as anyone of making a stray remark. He didn't even consider the statutory text of 1367, which both my friend and I agree is dispositive. And the easiest way to tell that it's dicta is if you cover up footnote 6, would it make any difference for the adjudication of the rights and responsibilities of the parties? Obviously not. Rockwell would have come out the exact same way, and the exact same outcome and judgment would have occurred. So
we have a lot of things and opinions that you can make that same comment about that we follow. Just to put that out there. Sorry to interrupt.
And I agree with you, Justice Kavanaugh. The fact that it's dicta doesn't mean that you toss it out the window. I think what it means is you take it.
That we don't even treat it as dicta, but keep going.
Well, it's up to you to decide whether or not you would treat it as dicta here. I think it's pretty ill-considered. And it doesn't get into the fact that it creates the inconsistency that we've been talking about, where the exact same text means one thing for an original case and something else for a removed case. I don't think that's the sort of thing that Justice Scalia would have countenanced, given his commitment to textualism.
Counsel, your friend on the other side, you finished?
Yeah, thank you.
Your friend on the other side says that this would wreak havoc with the Class Action Fairness Act and remove cases. Do you want to address that?
I'm not sure that I understand that point, Your Honor. I don't see why it would wreak any havoc. CAFA makes it a lot easier to remove cases into federal court. So in the mine run case, they're going to have no difficulty. The difficulty that they face here is that you have no diversity of any kind. CAFA obviously eliminates complete diversity and goes to minimal diversity as the standard, but that's a relatively unusual circumstance. Oftentimes, plaintiffs are trying to seek a nationwide class or something broader. So I don't think it's going to wreak havoc, because the incentives are still going to be there when there's widespread harm for plaintiffs to pursue classes that include citizens from many different states.
Counsel, we have had cases where we came out the other way than every court of appeals it had come out, right?
Yes, you have, Mr. Chief Justice.
Like what?
I think there are. That's a great question. And none spring to mind, but I am positive that I could find some.
Central Bank.
Well, I mean, it's pretty bold to take the position without knowing one.
Fair. Mea culpa.
Was that the case in Chadha?
INS versus Chadha?
Yes.
I don't know. I apologize.
Somebody will check.
Gosh, I'm not sure which way that cuts.
I'm not sure that's true. I just have it in the back of my mind. But okay.
I just go back to the state of the law. I certainly didn't use the word arbitrary. It's just that each bucket has developed based on its own idiosyncratic considerations, and you can't necessarily get a through line of look at the time of filing or the time of amendment, at least as I look at them. And it's beyond just amount in controversy. It's change in citizenship as well. I just want to, you agree with that on the change in citizenship?
I agree, obviously, that the change in citizenship rule has a long pedigree. It goes back to 1824. I don't agree that that's about which complaint controls. That's about real-world facts. So if you would amend a complaint to say, I made a mistake. I said that I was from Florida and the defendant was from Illinois, but I realized that the defendant actually moved to Florida 2 years ago, so we're both from Florida, the amended complaint would control there.
And then on footnote 6, let me just, I know you're going to disagree that it controls. If it does control, I mean, if it is binding, it goes against you in this case, correct?
Of course, and then I win under Grable or Merrill Dow.
Right.
And, you know, I just wonder, so you look at footnote 6. To me, footnote 6 is like somebody said, hey, but how about Cohill? And then they said, oh, yeah, Cohill, so we have to put in footnote 6. And so the fact that footnote 6 is there suggests a certain kind of reading of Cohill. And you know, what Cohill was about, it was this question of do you have to dismiss a case or can you remand the case back to the state court? But Cohill's logic does cut against you, I think, fairly heavily here. Because as I read Cohill, what it does is say something like this. You know, the supplemental jurisdiction business, ever since Gibbs, we've understood it as a completely discretionary area of jurisdiction. you can keep the case, you can dismiss the case. If you can keep the case and you can dismiss the case, surely you should be able to remand the case as well. And that's the essential logic of Cohill. It's like everything is discretionary in this area. Why shouldn't this be too? But that logic really does cut against you because it suggests that everything is discretionary in this area, including keeping the case.
Yeah, a couple of responses to that, Justice Kagan. Whatever amount of discretion I think existed in the Cohill era, I don't think can continue through binding statutory text. So we're no longer operating in a common law realm. We're operating in a realm where Congress chose to act. We can debate whether Congress chose to codify whatever the common law rules were, hook, line, and sinker. I would suggest from Alipata that it codified binding statutory text, and we should follow the text. So I don't think we can just go with freewheeling old principles now that Congress...
Well, how about if I think that the text doesn't really help either of you, that, that you're saying text, and in fact, neither of you really has a very strong argument about text, and we have to decide this case on other grounds?
So the other grounds, I think, would be the master principle that we talked about, that the operative complaint almost always controls. The only context that I'm aware of where it doesn't control is the amount in controversy. That, by the way, was also codified through binding text. That's 1446. I agree that it goes back longer to cases like St. Paul Mercury. As an aside, I actually think that's a completely defensible interpretation of the old statutory text, precisely because Congress understands it doesn't want to blur the line between jurisdictional facts and the merits. We don't want to create the Judge Posner problem where a plaintiff comes into court and loses or wins an amount that's less than the amount in controversy, and now we have to remand for lack of jurisdiction.
Do I understand what you just said to mean that you would win this case even if 1367 had never been enacted?
I think that I would win this case if 1367 hadn't been enacted and we were still in a more common law regime and this issue were squarely presented to the court for the first time. Cohill had this issue obliquely presented. Yes, there was an amended complaint, but the party presentation rule should matter. No one made that fact relevant for the court's consideration. You could have considered it sua sponte because it went to jurisdiction, but no one did. And this court has pointed out before that drive-by jurisdictional rulings don't have any precedential effect. The reason you had to say that is sometimes, even though you would like to avoid it, you issue drive-by jurisdictional rulings.
Why would we say Cohill address this? As I understand it, the question there was whether to remand or dismiss, and this issue wasn't presented to the court at all.
I completely agree with it. It was not presented to the court. The facts of Cohill, though, I have to say in the spirit of candor, was that there was an amended complaint, and it dropped the federal claim. And then there was the question of whether there's discretion to remand versus just discretion to dismiss for lack of continuing jurisdiction.
And do you have any way to rationalize St. Paul Mercury other than it's been codified now?
No, I do think that I can rationalize St. Paul Mercury. As I was saying just a moment ago, I do think that the amount in controversy, even before Congress said in 1446, we have to look to the initial pleading. Going back to cases like St. Paul Mercury, it is reasonable to read the words amount in controversy to mean theoretically possible to be recovered. It doesn't matter what happens after you file your lawsuit. And so if the plaintiff pleads in an initial complaint consistent with Rule 11 or whatever the equivalent was in 1938, I'm above the jurisdictional amount in controversy, that's showing that it's theoretically possible to recover that amount in good faith, and that's good enough for the statutory jurisdictional requirement that Congress added on to Article 3.
Mr. Keller, in thinking about, Justice Kavanaugh was talking about the different boxes and some of the inconsistencies. One way I've been thinking about this is I think it's been true for a very long time, back to Strawbridge versus Curtis and the complete diversity requirement, talking about Motley and the well-pleaded complaint rule, that the court for a very long time exercised a pretty free hand in interpreting 1331 and 1332. That language is identical to Article 3, but yet the court interpreted it to mean something different. And I think that in the Gibbs regime, pre-1367, the court was exercising a pretty free hand in articulating the contours of pendant jurisdiction and ancillary jurisdiction before Congress controlled it. Can you think, I think a lot of this case seems to kind of come down to, is that just the way we've been treating jurisdictional statutes, and do we keep it up with 1367? Or in 1367, because in Finley, the court kind of said, nope, look, Congress, there need to be clear jurisdictional rules, expressly invited Congress to address it, which Congress did. would you say, do you think it's fair to say, or can you think of a counterexample that in 1367, when it comes to supplemental jurisdiction, the court has tightened its belt and isn't being as freewheeling? Or can you think of other examples where this court has done kind of what the Court of Appeals seemed to have continued to do in 1367, which is maybe make a little bit more jurisdictional policy than was set out in the text?
Yeah, an important question, Justice Barrett. I think I would describe the history a little differently. I wouldn't describe it as freewheeling. I would say at all points in one direction, the court construed jurisdictional statutes more narrowly than Article 3. So that's certainly true with Strawbridge versus Curtis. We know that there's not a complete diversity requirement because of CAFA. It's the same thing with 1331. Justice Thomas noted this in Grable. From the very beginning of the Jurisdiction and Removal Act of 1875, this court almost immediately construed the words arising under to be not coextensive with Article 3. Gibbs is a counterexample, and the court in Finley, I think, gently criticized Gibbs for operating without a statute. It did invite Congress to act. Congress has now acted, and so having taken up this court's invitation to supply positive law codifying this entire area, I think you should stick to your normal statutory interpretation principles, and if you want to put a thumb on the scale, it should be against jurisdiction, consistent with tradition.
Setting aside 1367, going back to Justice Alito's question, I'm wondering whether the sort of core principles basis for your position is basically the plaintiff is the master of the complaint. They get to plead the claims. For federal question jurisdiction, the claims matter. That is, jurisdiction is based on the claims that the plaintiff pleads. If the claims are amended, the federal court can be divested of jurisdiction, and removal really has no bearing on the scope of jurisdiction, or at least that's never been established, that how it comes to federal court matters with respect to an amended complaint. Is that roughly where you're coming from with the principles that would underlie this, even setting aside the statute?
Yes, that syllogism is perfect. If there are no further questions, or I'm happy to go to Seriatim.
Justice Thomas. Justice Kavanaugh. Thank you, counsel.
Thank you, Your Honor.
Rebuttal.
Thank you, Your Honor. As Justice Kagan says, under experience, respondents lose. To rule for respondents on the question presented, this court would need to overrule or distinguish away St. Paul Mercury, Cohill, Rockwell, Gibbs, Carlsbad, Rosado, PowerX, Osborne against Haley, International College of Surgeons, and Wisconsin Department of Corrections. That's 10 decisions of this court, on top of dozens and dozens of Court of Appeals decisions that have consistently and unanimously supported petitioner's petition. Indeed, even respondents agreed that the district court could exercise supplemental jurisdiction. They said it in their amended complaint. It's only until the Eighth Circuit invited briefing on this that they switched positions. And I think it's quite telling here that the Eighth Circuit reached the decision it did by apparently missing all of the footnotes that it should have read, including in Rockwell, but also in the Second Circuit and the 11th Circuit decisions that it cited. So I think that's the reason we're here today. As Justice Barrett asked, ruling for respondents would also call into question the rule that applies in CAFA cases. The Court of Appeals have said, if you get into federal court on a removal in a CAFA case, the plaintiff immediately amends to try to get rid of all the class action allegations. The courts of appeals have said that's a question of discretion for the district court. Maybe the district court will send a lot of those cases back to state court, but maybe when the case has been going on for 2 years and the class is about to get certified, that's a situation in which the district court may say, okay, I'm going to keep this case here in federal court. It would also call into question the court's longstanding rules that amendments to the amount in controversy do not affect jurisdiction. And what do respondents want instead? So instead of an approach that gives district courts discretion in every case to determine what makes sense as a matter of judicial economy, convenience, fairness, and comity, They want an inflexible rule that gives district courts no choice and that would subject the defendant's right to removal to the plaintiff's caprice. As the Chief's questions suggest, where this court decides to overrule every single court of appeals, it should have a really good reason. And there isn't a really good reason here to upset a longstanding jurisdictional rule that has worked just fine for a century. The Eighth Circuit simply got it wrong, and this court should vacate the decision below. Thank you.
Thank you. The case is submitted.
The Honorable Court is now adjourned until tomorrow at 10 o'clock.